Andy. Thank you very much.
Andy
Good afternoon. My name is Andrew Maternowski. I'm an attorney. I practice law here in Indianapolis, but most of the work I do is around the state. I won't claim to have handled as many cases as Mr. Dillon, but I did work with him for a number of years, and I've been close to 80 counties, so I've been around the state as much as he has. We've heard a lot of talk today about what could be done, what maybe should be done, and reasons why we should do it. What I've presented to the committee are some suggestions about how we would actually do that in implementing some of the laws and suggestions about changing the laws in the state of Indiana where marijuana is concerned. There's a handout being passed around that has my contact information on it, and of course I'd be happy to discuss any of these changes with anybody that's interested. The first suggestion I have has to do with a conditional discharge for a first offense possession of marijuana arrest. In Indiana, we have a statute for a conditional discharge where if somebody pleads guilty to a judge, the judge may essentially put them on probation under appropriate conditions, substance abuse assessments, treatments, drug screens, community service, paying fines and costs for those services that are rendered by probation typically. And if they complete those programs and do everything they're supposed to do and stay out of trouble, essentially for up to a year, the conviction actually is not entered, but the charge is dismissed, and there's no conviction on that person's record. That is significant in Indiana because you have a situation where you have first offenders, typically, maybe a high school or a college student. If they are convicted, they are no longer eligible for federal financial aid. I know myself, without financial aid, I wouldn't have been able to go to Purdue or IU for law school, and I would not be here today. Okay? That there are a significant number of people that I represent every week throughout the state who that impacts. What this would allow, a simple change by making a conditional discharge mandatory on a simple possession of a misdemeanor amount of marijuana for a first offense. A person could simply go into court, admit their guilt at their initial hearing. At that point in time, the judge could place them essentially on probation, monitor their progress, monitor their substance abuse if they're using through drug testing, make them do community service, go to drug education awareness classes, and when it's done, there would be no conviction. That case would be over for them. It is permissive at this point. The problem we have in Indiana is that, in my opinion, not enough judges allow that and won't use that. I think it's a simple way that we could lessen the harshness of the laws in Indiana. The next page I have refers to removing misdemeanor marijuana offenses from the list of HSO, habitual substance offender predicates. Our Habitual Substance Offender Act in Indiana, if you work your way through all of this, a simple way of saying it is a third strike, puts you in a situation where you're looking at anywhere from 3 to 8 additional years on top of the new predicate offense that you've committed and been convicted of. That puts you in a situation in Indiana, under certain circumstances, at the outside edge, where you could get 16 years for dealing or having marijuana within 1,000 feet of a school. That misdemeanor would get enhanced to a D felony. It would then qualify for habitual substance offender. It could also be enhanced to a C felony. So you get up to 8 on the habitual substance offender, up to 8 on the C felony. They're mandatorily consecutive. You're looking at up to 16 years. Okay? With the proposal that I have would simply remove misdemeanor violations of marijuana possession and dealing from habitual substance offender predicates. The third suggestion I have is a situation that I've run into. You have a group of students, college kids, teenagers, driving in a car. One person has marijuana in that car. They're the backseat passenger. In most counties, they would probably get that conditional discharge that I referred to on the first page. However, the driver of that car would be the person maintaining that vehicle. That is a felony. So you have the interesting situation where the person who is not smoking but is maintaining that vehicle, perhaps for the other people, could be charged with a felony, not eligible for a diversion, looking at a felony conviction on their record, whereas the person who actually had the marijuana would be looking at probably at most a misdemeanor, obviously, or a conditional discharge or a prosecutor's diversion. I think simply changing the level of offense for a common nuisance when the controlled substance involved is marijuana to make it equal to the actual offense of possession of marijuana makes a lot of common sense. It simply doesn't make sense to have somebody who isn't possessing that drug be punished more harshly than the person who is. The last, page 4, or the fourth section, in Indiana, a number of years ago, the legislature passed a bill that provided for a license suspension of your driver's license if you were convicted of any controlled substance offense. A few years ago, 5 or 6 years ago, that was changed to require that a motor vehicle had to be used in the commission of the offense. Prior to that, you're sitting at home, smoking marijuana, you get arrested and you get convicted. No car involved whatsoever. You lose your driver's license. You lose your ability to register a motor vehicle, and your registrations are terminated or suspended. No car involved whatsoever. Luckily, there was a change to that at least required a court to find that a motor vehicle was used in the commission of the offense. I don't feel that's gone far enough, and this changes, one of the things that prompts that change is that if you have a person who has marijuana, a passenger in a car, judges throughout the state, there's a reported case recently out of Hamilton County where the Court of Appeals upheld that provision, a passenger in a car with marijuana on their person is losing their driver's license, ability to register a car, and the existing registrations are suspended for 6 months. That makes absolutely no sense when the idea, in theory, is that we're trying to have safer drivers. Okay. The change in the time also would make this more comparable to operating while intoxicated. As the laws currently exist in Indiana, somebody is driving drunk, possibly endangering people, maybe killing somebody. They can get their license back within 30 days by getting a hardship license. And they're back on the street driving. If you are in a car, you're convicted of possession of marijuana, no operation of the vehicle actually being involved, no endangerment, no nothing, you lose your license for 6 months. You also, as it currently exists under subsections A, 2, and 3, that I've stricken out as a proposed change, your existing motor vehicle registration is suspended and your ability to register a motor vehicle is suspended. You're married. Your spouse gets arrested. Their license gets suspended. Your car is registered in both of your names. Your current suspension invalidated. You have to go back. You have to retitle. You have to redo everything just so your wife or your spouse can still drive that car. One of the problems with a driver's license suspension is that it prevents people who need treatment in rural counties, which most of Indiana is a rural county, from getting to where they need to be to satisfy their court obligations. Without a driver's license, you're not going to have a bus that's going to take you, from one of the rural towns that you might live in to the county seat where there might be a treatment program. You're not going to have a ride when your suspension kicks in. How do we expect people to rehabilitate themselves, continue to work, support themselves when they don't have a driver's license? This would address one of those. I've also suggested removing subsections 6 and 7 under subsection 15. Those refer to simple possession offenses, where we would only suspend a driver's license if the offense involved dealing a controlled substance by the person who was operating the motor vehicle and the vehicle was essential to that offense. Section 5 refers to the statutes as they currently exist in Indiana for operating while intoxicated offenses. In Indiana, the statute currently prohibits operating with a metabolite of a controlled substance in a person's body. If you are a medical marijuana patient or you have been to a state where marijuana is legal or a country where marijuana is legal, and you smoked marijuana and you came back and 25, 30 days later, those metabolites, every scientist in the world would agree that they are inactive. Psychoactive effect has worn off completely. They are still in your body. Under our implied consent laws, if you're suspected of operating while impaired, you're going to have to give a blood sample or a urine sample. And your urine is still going to test positive for what everybody believes and knows to be an inactive metabolite of marijuana in your body. No effect whatsoever on your driving, yet we punish it exactly the same. What I would propose is that we only restrict, and criminalize driving with an active metabolite in a person's blood. Essentially, that says we're going to prosecute you for driving while you are high and impaired, not for having metabolite in your urine that's still exiting your body from what you might have smoked months ago. The idea is to protect people from dangerous, impaired drivers. Testing people's urine and showing what they used a month ago when they weren't even driving makes absolutely no sense when that's our purpose. And by comparison, if you look at the second page, our statutes involving unfortunate incidents where people are killed by drunk drivers already requires a metabolite in the blood. I would change that to still require it to be an active metabolite. So we're actually prohibiting conduct that causes a wreck. There is no toxicologist. There, I don't believe, is any prosecutor, no expert who will tell you that an inactive metabolite of marijuana in someone's urine causes any sort of impairment whatsoever. Lastly, I have one point that I would like to make with regard to an issue that was mentioned in Senator Tallian's opening remarks, and the doctor talked about the increasing number of people who are growing live plants in Indiana and how the market is shifting to something small and home-based. In Indiana, we define marijuana to exclude the mature stalk of the plant. The problem we have right now in Indiana is that the state police and their lab define mature stalk as one thing, and mature stalk does not include the entire stalk or main branches of the marijuana plant for purposes of the state police. By contrast, you have Marion County. Marion County's crime lab defines mature stalk as everything on that entire stalk up from the first set of leaves on a marijuana plant. You're looking at a 75% difference in weight, strictly based on which lab in the state decides to test and weigh that marijuana. Additionally, until recently, Marion County's crime lab weighed marijuana plants wet, another 75% increase. I have a single case that is on appeal right now where the difference was 266 grams, which is a felony amount, compared to 17 grams if it were weighed by the state police. So there is a difference in how we should define a marijuana plant and how we should weigh marijuana when it comes to plant. I would propose that it be required that it be weighed dried, which is how it's marketed and used, and that the stalk and the main branches, which have virtually no THC, no psychoactive effect, and are essentially discarded, as well as most of the leaves by most people who are growing marijuana, not be included. Again, my contact information is on my cover sheet, and I'd be glad to talk about this or answer any questions. Thank you.
Thank you. Questions, Brandon?
These are probably the most efficient way to change some of the things. As far as lowering the threshold or just making, that would be fine too. Well, under federal law, it wouldn't help anybody with financial aid. A conviction is still a conviction. You would still lose your driver's license and you would still lose your financial aid. And any controlled substance conviction requires a loss of financial aid. Yes. Yes. As the law exists right now, I don't believe it would. I don't think Indiana, there's no statute that provides for it. Yes. I believe it would. The problem you have there is that a lot of doctors are licensed by the state and by the federal government, and they're very hesitant to go on record saying that they are recommending a patient to use that. A lot of doctors will tell you, yes, that's fine, but I'm not going to go on record saying that, and I'm not going to put it in your chart. Doctor could lose his license to prescribe. I don't think you could control what the federal government would do if it's a DEA license. Pardon me? Yes. Depending on what the Attorney General decides to do. That's been up and down. Thank you. Thank you very much.